of the ordinance. We're going to talk about historic preservation districts and conservation districts. The way we'll work it is Michael will give us an overview of that component of the ordinance. Then the commission will get a chance to ask questions and make some comments, and then we'll open it up to the public to make comments. And I'd just like to remind you all to turn your cell phones off or put them on silent. And what we'd like to do is, if you want to make a point and it's already been made by someone else, we'd ask that you not make your point, so that we're going to capture all of the comments, but we also want to make sure that we handle this as quickly as we can. So the first item is item 10-6-7, historic district designation.
Thank you, Chairman. The historic district designation is a renumbered section, and it's been significantly rewritten and reordered to provide a more clarified procedure. It includes an itemization of all the information required for an actual nomination, identification of fees that are the responsibility of the applicant, filing requirements, a review schedule by staff, a requirement for timely notification of the owners of the property within a proposed district. It addresses withdrawal of an application, timeliness of review, which is reduced overall compared to the existing ordinance. And that is the timeliness of review not only by the commission but also by the city council. We have added in a requirement for a supermajority approval at both the commission and the city council for districts that are nominated with 51% or more owner objection. There's a requirement for the suspension of all work while the application is considered. There's a reapplication process outlined following a denial, a process for amending an application following approval primarily for minor, both cases of minor material omissions, and if there's a major error, there's a process for that outlined as well. And then
Can you speak up just a little bit?
And
Get
then
a little bit louder.
Okay, and then the process for rescinding the district designation is outlined as well. The text outlines the standards which must be met for district designation, and the section is now written to mirror the landmarking process. That is the basic summary.
All right, comments from the commission on this section?
Do you want me to highlight any of the particular changes in the section?
Why don't we wait till the end, then we'll,
Okay.
once we get through the whole thing, then we'll look at the changes.
Okay.
Or you're talking about the changes from the existing
No,
ordinance?
it just changes, guessed or made a couple changes based on last month's, or last week's discussion, that I'm suggesting that we also add in a pre-application meeting as the first part of the process. So if anybody has that as a concern, I just want people to know that we have already included that as a recommendation to have a pre-application meeting.
So a pre-application meeting.
Correct.
So are there any other changes from the ordinance that we looked at?
Not from what you have in front of you.
Okay. All right, comments from the commission?
I just have a question, and I think I know the answer to this, but I can't find it quickly. Once an application is filed for the district, is that a suspension of work throughout the district until it's resolved?
Until it's resolved, however, I'm also anticipating that you're going to want to revise the language, as we discussed under landmark district, that it would be a suspension of all work that had not been previously permitted,
Right.
Okay.
and that is my recommendation.
A minor issue on page 18 in part 1 called application. Just to be consistent, we've used the terminology owner of record, and on line 1, 2, 3, 4, 5, line 7, it just says obtain the consent of the owner. Perhaps that should be owner of record.
To that, I would also recommend that the first sentence be written to be parallel to the the language that we adopted last meeting, which would be identifying group of residents or association with resident members.
Any other comments?
If the, you can withdraw by owner objection if it's done in a timely manner, is that correct?
You can, according to the way that we have designed the process, that if 51% of the owners of the property is objected within, I believe, it's 10 days of the public hearing, then it would automatically be withdrawn. If it's after that 10 days, it doesn't give staff enough time to verify that all of those are the owner of record, so it would continue on to the public hearing. That's why we have that 10 days set, 10 working days.
So what's the supermajority needed for then?
If it were to proceed to public hearing, even with the owner objection, and the commission chose to adopt it by a 2/3 vote, then it would go to the council, and they would have to approve it by a 2/3 supermajority vote as well.
But if 51% were verified even after the public hearing, then it would just automatically be withdrawn.
No, it would still go forward.
It would still go forward at that point.
Yes.
Why would it still go forward, though? It doesn't seem consistent. Is it just that, I mean, it takes that time to verify it, but it seems like a timing issue, and I guess the will of the people would be said that I don't think that a commission would vote for something then, if that were the case, so.
Yeah, I agree with Paul. It kind of seems like a gotcha.
Yeah, I mean, it's like, we've got this 10-day thing, and if it doesn't happen within that, before the 10 days, then, oh well,
Yeah, it's like, if you had filed it yesterday,
It would have been fine.
But today,
What does that do with the timing? Because once it's set in motion, we're kind of locked into a clock, aren't we?
Correct. I mean, it has to be published for, within 15 to 30 days prior to the public hearing. And I guess our thinking was, when we were looking at this, is that it's been published, the public has been notified there is going to be a hearing, there's no way to really tell them it's not going to be a hearing. So it seemed to us that if it was published for hearing, that it should go forward, at least as a public hearing, and then the commission can decide if they want to approve it or not approve it. And I would think that if 51% had been documented, by the time of the public hearing, that there was 51% objection, I would think that the commission would probably take that into consideration or deliberations. I would expect that to happen. But I don't think, the issue is that in that 10 working days, if it's within that, less than that 10 working days, it could be the day before the public hearing, and staff may not have time to verify all that ownership. And so that's,
I guess I don't understand. So we have a public hearing, okay, and then we verify that 51% in fact do object.
Then it just dies at that point. Why
Right.
wouldn't it just, it's like, well, okay,
Okay, oh, well.
okay. We had a public hearing, but it really was it was a moot point because 51% of the people decided not to support it. I mean, it doesn't seem like timing should be a problem in that issue.
it doesn't say in the ordinance that you have to come to a fine. It says the public hearing will continue if the 51% isn't verified in that 10 days. So it's up to the commission to decide what to do.
Yeah.
But why are you giving it to the commission at that point? Why not just say that, because it's kind of a gotcha at that point. We could have a commission that says, okay, now we've decided that this is good enough, that this meets the historic district designation, and 51% of the people didn't want it, but it was a matter of timing that they didn't get it done in time. I mean, it seems like if timing shouldn't be part of that.
Well, I'm confused with what both of you were saying. What I thought I heard was that within 10 days, the 51% say that they do not want to be part of a historic district. But it has to go to the public meeting because there's no way of calling the public meeting off. So then I don't see where the gotcha is if after the public meeting, it's verified that 51% did in fact legitimately say no, and then the issue dies. Where's
Well,
the
no,
gotcha?
no, actually,
Doesn't
what
die.
it says, it doesn't die, because
Doesn't
what it says is, what I read it as saying is, if they don't get the 51% in by 10 days before, then we as a commission can vote to say that it is a district, and it will go on to the
Okay.
city
Paul,
council.
Can you show me what page you're on?
I'm on,
I'm not seeing that.
it's actually on page 21. It's
Yeah.
about two-thirds of the way down. And it says, in the case of a hearing application designation where at least 51% of all property owners declare in writing on a form provided that their opposition in less than 10 days prior to the public hearing, the commission shall have the public hearing,
Shall conclude the public hearing.
but not act upon until the regularly scheduled meeting of the commission.
When the authenticity and accuracy of the objection is verified by staff.
Upon verification of lawful objection, that by two-thirds vote shall make a recommendation to grant or deny. So that's, we still have the,
Oh, I see.
so after, we still have the power to say, we think it should be a historic district.
So that last sentence needs work, in your point of view.
Well, I don't know, it seems to me that it's kind of a gotcha situation, where the people could be late one day, and then it has to go forward to the public hearing, and there's a chance that it could become a historic district, even though 51% of the people don't want it to be.
Well, I will give you an example, and I have seen this happen in one other community, where a historic district was proposed with the same type of 51% requirement, not this language. But,
Yeah.
the night of the public hearing, it was thought there was a 51% objection. By the time the whole hearing got done, several people withdrew their objection, and there was not a 51% objection anymore. So again,
But that's not really, that's a matter of education, and that shouldn't be part of whether 51% object 10 days before or 9 days before.
well, but part of the purpose of a public hearing is to gather the facts. And so if that alters someone's, opinion about a district, I mean, that is the purpose of a public hearing, is to gather all of the facts so you as a body can deliberate as to whether there's sufficient support or sufficient reason to move forward with a project.
I hear what you're saying, but also the gathering facts is like for the public as well. And so somebody who maybe attended the hearing and withdrew their objection at that point, then it would have moved on. I also understand that there should be like a time where it's like, okay, on this day, it either happens or it doesn't, but perhaps that could be after the public hearing. So that everybody can get all the facts before it moves forward? Or does the public hearing and the vote take place on the same time?
It can,
It can, but does not have to.
doesn't have to.
The
I
commission.
don't know, it feels to me that just because of a district, there's so many owners involved, and there's so much confusion involved because of these things, that we would definitely want everybody to have all the information before, a decision is made.
Well, and that's one reason why the commission has 45 days to act. So that allows for time for you to take another 30 days to a regular meeting to make sure you can assimilate all the facts that are presented at the public hearing before you make a decision. And the same thing could be happening. There could be rehabilitation of opinions during that 30 days. There could be, more people could come out and object to a district. I mean, it's not just one way or the other. I mean, it's both sides. I mean, the facts could come out that it was a very poorly recommended district, and that maybe 75% actually object to it. But you won't know all of that information until you've had the public hearing.
But after the public hearing, if 75% object,
It could still go forward.
still go forward because two-thirds of the HPC could say, no, we still want it to go forward, and it could go to the city council where two-thirds could say, it's still going forward despite the 75% who say, no, we don't want it.
Okay. At first, I thought you two were saying the same thing, and now I feel like you two are saying opposite things, so.
No, we're saying the
They're
same
saying the
thing.
same
We're
thing.
saying the same thing. We speak
Yeah.
architect.
Well, again, I
Hold that
mean,
against.
there's also the very real possibility that you have a district of, remember, districts can be as few as 2 buildings. So you could have,
That would be, so how do you get 51%?
well, that's the reason you have to look at all the, that's why you have
That's
to
a
look.
problem.
Well, no, you have to look at all the legal owners, and you may have a property that's owned by a corporation that's looking to clear a significant property. And so they may have 51% by the number of owners of the properties. So, you know, you could have trusts or whatever involved in it. But again, this is trying to come up with a language that would work for almost any scenario. And, you know, there gets to be a point where the commission has to use logic that if you're, you know, if you're talking 100 property district, and you have 51%, that's a little easier of a case than if you have a 2-district property that somebody, or 2-property district that somebody has nominated, and it's a significant structures that say, 2 just investment companies have purchased and want to clear, but yet they're very important buildings to the community. So I mean, there's a lot of different scenarios. It's not just the large districts that you're looking at. So it's.
Well,
So
I'm
how
gonna
would
make
you
a
see
stab
changing it?
At changing it. And this is maybe not the most finessed thing, but what happens if we have everything in the public hearing, but instead of voting at that public hearing, we have another hearing to do that, or another meeting to do that, where, in other words, you don't vote at the public hearing, you vote at the next one, and if 51% file by that hearing, you know, by the vote, then it moves forward. Or 51% don't file by the vote. Are you following me?
Yeah, I follow you exactly.
Yeah, 'cause
Is everybody following me?
So you want to forbid any discussion and voting by the HPC at the public hearing?
No.
Not the discussion.
The vote.
Just the vote.
The vote, okay.
So in other
you
words,
wanna
it's kind of
forbid the
like the
vote.
committee of the whole, where you're talking about it, but you wait till the actual meeting
Okay,
to do the vote. And then that would allow everybody to be educated and to hear all of the discussion and to be fully informed all the way up to the vote. What do you think, Paul?
I would agree with that. I think,
Okay, but I thought that what you were looking at was saying that if 51% signed a form, then we would stop right there without a public hearing.
well, it sounds like, though,
It would happen regardless, right?
I kind of like the idea of going through the public hearing anyway.
I
I do
kind
too,
of
so
agree with the
everybody
public
hears
hearing, but,
everything the same.
but I still think that if 51% end up having an opinion that it shouldn't go forward, I still like the fact that that stops the process. But maybe that has to be after the public hearing, though.
Right.
And maybe for simplicity, too, that it doesn't change, you know, there's
Yeah,
not
yeah, it
this
could be
wishy-washy thing.
flip back and forth.
How does that sound? I mean, you guys are the ones who are ordinance experts. I'm so not.
Just kind of sidebarring here, it seems to me that the automatic withdrawal is part of the problem.
Right.
Regardless of the time frame. If 51% objects, we should still hold the public hearing.
Right.
I don't, even after the close of the public hearing, if the commission postpones action until the next meeting, it still seems that a formal action should be taken. And if there's 51% objection, that's why the supermajority vote is required.
Right.
So it's up to the commission to decide whether or not to approve or deny the request based on the amount of objection.
So what you're saying is then that it would be that if 51% said no to the thing, it would not, after the meeting, the public hearing, it would still go to a vote for us.
Correct.
But we would have that information.
The public hearing would have been held and you would have heard testimony from both sides.
Where did you get this 51%? Was that from other ordinances?
Yes, 51% is in not only the model ordinance from the state, but it's in most ordinances, not all. Some ordinances have less, some have more. There are some that have as high as 66 2/3%. There are some that have as little as 30%.
I don't know.
I
If it's a state thing, you know, it seems to me that the automatic withdrawal should hold sway. I mean, it should be enforced, but as I said, I think that it should happen after that public hearing, but before the vote, because then everybody gets all the same information.
So then should those forms that are filled out, should those be dated after the public hearing?
Not necessarily, because presumably, you know, kind of like filing petitions for an election, you can get them anytime, but somebody could cross their name off and date it, you know, so that,
That
The-
if
the
they
date-
change their mind,
you know,
It seems to me that you would not want to automatically require it go to the next meeting for a vote. It may be a very clear case that a poor district is assembled, and it's very clear that the, you know, staff has had time, again, not looking at these mega districts, but what if it was a 5-building district? It'd be fairly easy to check out all the landowners and what have you, and be able to report back to the commission at the conclusion of the public hearing at that meeting. And if it was a poorly assembled district that somebody wanted to put forward, I would think why would you want to automatically be forced to wait for 30 days to vote at the next meeting?
well, we don't say it has to be 30 days.
Well, you were just saying that you wouldn't vote, you would make it so that your vote,
We could
you would
choose
not
to have
vote
another
until the
meeting.
next regular meeting. And right now, you're not tied to that. You could vote right after the public hearing if you wanted to.
I guess that I don't see the rush, especially in something as
Right,
important as a
right.
historic district.
There shouldn't be any rush.
Right, I mean,
Can you say
you
in the
don't
language
necessarily
that,
have to wait 30 days, kind of like we haven't waited 30 days between February 24th, when we met last, and today,
And now.
which is, I don't remember
2
what day
weeks,
it is, the
2 weeks.
10th. So we could say, okay, we're going to vote on this in a week, or we could set that, but it would automatically be done at the next meeting.
well,
if
that
we
last
had
paragraph in 41, it just says we'll vote within 45 days. So
Right,
we wouldn't have to change that.
because it's possible after the public hearing, something might come up that would require more research or whatever.
Correct.
But I suppose, I mean, if we had, as I said, I just don't see why you would want to rush it. Can you think of a reason why you would?
I can think of several reasons that
Okay.
if, again, going back to a small district, say it's a group of developers that have financing on the line and they want an answer about whether or not it's going to be landmarked or not, 30 days can be a big difference to a development proposal.
So it's possible at that time we can say, okay, we're going to reconvene in an hour to vote on this because we have all of the developers with us and none of them are objecting.
If it's a pretty clear-cut case, once the public hearing is closed, that very evening, you can vote, once the public hearing has been closed. There's no need to have to continue it to another date.
Right, exactly.
Right.
But on the other hand, if it's not such a clear-cut case, if it's hundreds of homes, and I'm not saying we're planning that at all, by the way, if it's hundreds of homes, then I don't see the harm in waiting 30 days.
There's nothing
There's nothing that says-
requiring you to
it
vote
just says
that night.
within 45 days.
It gives you that full time that you're asking for, the way it's written right now.
So what we started with is that first section, which says if 51% object, then it automatically gets denied. So that's what we were talking about, so is
Right,
it,
and what Paul and I think we were saying together is that that should occur after the public hearing. And what,
well, but it's kind of morphed into something slightly different in that it seems like it's still going to have a vote.
Right.
Whereas if it, at 51% before the 10 days was just, it was dead. Before the 10 days before the public hearing, if 51% of the people that were, said no, of the owners said no, it was, we wouldn't have even had the hearing and it would be, it'd be ended.
right, but we're saying that that wouldn't occur either, that no matter,
Yeah.
all applications would go to a
that's what
public
Paul
hearing.
was talking
Oh,
about. is
Yeah,
so
I'm
we're
just saying
agreeing.
All
that,
the way up to the public hearing,
And then
we
at that
could-
point, what David is suggesting is removing that 51% objection,
To-
except that that would somehow be taken into account by the two-thirds vote.
right. and I think that's what you object to, is that we could still vote on, even though more than half the district does not want it, we
Yeah.
could still vote in favor of it.
Yeah, that's kind of what I'm objecting to.
I think we're still on the same page, because I think that that should be retained as well.
Yeah, because I think that if 51% of the owners think that it's a bad idea, I think they should have their,
Right, and they've heard all the evidence, and they've been to the public hearing, just like we have.
No, not right, that's not what you're saying. You're saying
well, no, I'm
up
saying that,
until the public hearing, if 51% says no, we stop, there is no public hearing.
Wait, I thought we were saying the same thing.
we kind of are. I mean, but you're saying even if after the public, I do see a problem in that we have to have like an end date of, okay, these signatures have to be in and verified at a certain time so that they can actually be,
No, I'm not saying that. The only end date is the vote, is the day of the voting. So the 51% have to be in by the day of the voting. If they are in, we don't vote because it's dead.
oh, well, see, I have no problem with that. I mean, because I want to
Right,
hear,
so all the way up to we vote, the 51% can gather their signatures and gather their ideas and hear the hearings and hear all the information.
So then would you be saying 10 days prior to the vote?
I would say even
The
up to.
city has to have a chance to verify.
Oh, to verify them, so 10 days prior to the vote, that kind of,
So play this out, we have our public hearing. We don't have all these forms in yet,
right? And
so then we
then,
can't vote.
so then 10
if-
days after, or it's 10 days prior to the vote.
And if there is not an objection, so we don't have any forms, that's stopping us from voting.
Couldn't we change the language a little bit to have a way to close the issue? Couldn't we have the public hearing, have all the forms verified, and if it has been verified that 51% plus dislike the new historic district, that we have a motion to withdraw the historic district, and we vote on the motion. That would add closure to the whole process.
Okay, I have another suggestion. I say we throw this back into Michael and David's lap and say, this part we're having problems with. You've heard what we've all said.
Right, but
Maybe we don't
haven't
come up
given
with
them
it
any
right
direction.
now.
I think what I'm hearing, to me, it really sounds like the automatic withdrawal process is kind of the problem.
I would, can I interject just that I don't think that's the problem. I think the problem is the timing.
Well, that tied with the timing, if the commission feels strongly that any district nomination that has more than 51% of its owners objecting ought to be denied, acting on that request with the requirement of a 2/3 majority vote to pass it shouldn't really be an issue. You would just vote it down.
Yeah, but the commission could have a different opinion than the owners.
Well, what we're saying is that we want to retain the automatic rejection of the district at 51%, despite what the commission thinks. But what we're having trouble working out is the exact timing, because of the requirement for you all to verify signatures, et cetera.
With a district, the ultimate vote lies with the city council, so it seems to me that the 51% objection should be verified prior to council action.
And it would die at that point?
Well, actually, that
I mean,
makes a
I
good
think
point.
we'd have
What
to-
happens if we have the public hearing, and then the 51% need to be in by our vote, we vote, and then if that 51%, and presumably it's 10 days before the city council would take action, if during that time those signatures are verified, then it dies at that point.
I think I'd like to review it, I think, with our city attorney, because I believe the applicant would have a right to have their request acted upon by both the commission and the city council, regardless of objection. It might be a case where it's not a district that's being proposed by the Historic Preservation Commission.
Could be a group.
And that's why, when you have more than 51% objection, you have the supermajority vote. We're trying to keep this very consistent with what we do with our zoning petitions. And with zoning petitions, if 51% of adjoining property owners file what's called a legal protest, then it trips a supermajority vote from the city council for approval. It doesn't automatically withdraw an application.
Well, as I said, I think that then, at this point, we should just throw it back at you all, and then have you, you've heard what we've had to say. You can smith it as much as you want, talk to the attorney and get it all worked out, and maybe come back to us with a different draft, because I'm not willing to kind of figure it out on the fly here. I don't think that that is a good way to do it.
Any other comments? Any other components?
And again, for clarity, do you remember how we changed the any person, groups, of blah, blah?
Yeah.
That's also in number 14 at the first.
Correct. That's all been picked up in my internal draft. All of your comments for parallelism.
Just a brief question for Michael. This particular form that people will be signing or responding on about whether or not they would like a historic district, are you envisioning that's an individual form that each person will deal with and then send to you? Or are you thinking of a door-to-door petition sort of thing? Have you given any thought to that?
I think they already have the form.
Yeah, well, it would be an individual form.
Okay.
So we can make sure we have the information needed to verify each property owner.
Okay, all right, good, thank you.
Right. Anything else? All right, let's open it up to the public. Yeah, Marty. State your name and address.
Marty Smersage, 909 South Batavia Avenue.
And this has to do with districts. This has to do with districts, designating districts.
Yes,
Okay.
I've understood that. Interesting conversation, and of course, I'm listening to it with a different set of ears. I'm listening to it as a member of a neighborhood that had a suggestion that they be made a historic district. And in reference to your point about 10 days, I'm thinking, my gosh, if as a district, I want to gather 144 signatures, and that's the number that was suggested last time, I've got 10 days to stop this railroad train.
Really, I think it's 20, because I think the public notice stuff has to be up 30 days before the meeting. And the ordinance says that you have to have all your signatures in 10 days prior. So I think it's 20 days.
Actually, it's more than that, because if you read the notification process, once an application is filed, we're requiring two sets of mailings now
Okay.
instead of the one, where in a traditional zoning case, there's only one time you're
Okay,
notified.
I
So now we're
agree.
notified at the
30
very
days is-
beginning of the process, and it could take 30 to 60, 90 days, whatever it might take to remedy any errors or what have you. So you would be notified very early in the process, so it's not just 10 days.
I agree with you. If it is indeed 30 days, that is just about enough time to gather those signatures. Now, we did it by a petition last time, door to door, and it was a nightmare. And we were under a much closer time frame to do it. And now I hear you saying that it's not by petition this time, and we have to object. It's not by petition, it's filling out a form at the city hall or in some manner that you can verify it when I'm signing the form. That's very different than a petition. And that makes it much more difficult for those object to post their objections. So I'd ask that you consider that. But I think it goes to a basic premise here that if you'll permit me, I give you a whole different suggestion on how to proceed. and that is that the concept of owner consent, please don't dismiss it, not yet, not until you've heard a lot more about it. It was supported by 254 signatures in 2014 that asked for owner consent. It was also supported by an additional 100 people, or 100 signatures in 2011 that signed petitions. So there's considerable input from the community that says we would like to see owner consent. The state of Illinois, the Historic Preservation Agency, in their certified local government sample ordinance that Michael referred to, actually says the petition shall contain the names of no less than 51% of the owners. The petition meaning the application. So if you turn this whole thing around and said, okay, there is darn good reason to make my district historic, and there might be, and who's going to look into it? The experts are going to look into it from this side of the room and the experts from this side of the room. You can't find anybody more qualified. How about a process based on education and agreement? How about get agreement from 51%? That would be consistent with what the certified local government recommendation is, a positive agreement. So once that positive agreement is put together and it's brought before this commission, go ahead from there forth. It should be a smooth sailing to go ahead. You have the majority of the people want it.
So how is that education process happening?
Mr. Lambert, part of his job description in
I think what we're trying to say is that public hearing is the education component that you're talking about. So we need to go to a
Okay.
public hearing so that
well, that's fine.
both sides can speak
Yeah,
and.
I think that, whatever way you see fit. Now, I've got to say that we were part of what was supposed to be public education in 2011 at the Public Works station. And boy, it's got to change, because that created so much discontent that it brings us forward today with the 300 signatures that say, hey, we don't want any part of this. We don't want you to expand outside of the current historic district. So the education has to be properly funded. This commission's not funded to do it, but it's part of your description, part of your requirements. You're not funded to do it. You're a half-time employee. So if you take the subject of education serious, in fact, if you take this whole proposal here serious, it should go to the city council with a request for an increase in budget to properly fund it so you can educate in a public hearing. And educating in a public hearing should be done by a professional educator with the kind of background that Michael has. I haven't seen him in an educational setting, but if he's not the person, he ought to be able to bring somebody in that can teach the reasons for it. Because preservation based on agreement and based on education is really strong. The National Register suggests that you have owner consent for designation for historic districts. So you have the state and the National Register both suggesting it. If you move a little closer to our hometown, you'll find that the city of Aurora, the city of Batavia, the city of Elgin, the city of Glen Ellen, the city of St. Charles, and the city of Oak Park, which is the poster child for preservation by education. I mean, they do a fantastic job. They all have provisions for owner consent. Why not us? The CLG that, talk about education, you have to have money for it. Get a grant from CLG. In the past 12 years, or the last 4 or 5 years, they've given away $500,000 in grants. We've applied for zero. The last grant we got was I think it was 12 years ago. In 2013, they gave away grants to every single city that applied. Now, only 14 were smart enough to apply. Maybe only 14 of the commissions were properly funded to apply. And of those 4 cities, or of those cities that applied, 4 of them required owner consent. A 5th city required 66 2/3. An additional 2 cities required owner consent even for landmarking, which I know is a difficult thing to get passed for this commission. We asked for 51 owner consent to be included in the application. So get all this negative stuff away so that when you talk about preservation, you're not doing it based on declaration of opposition. You're not based on the negative, base it on the positive. Base it because the people want it, because you've been able to convince them it is the best thing for the city, and it's the best thing for the individual homeowners. I believe there's merit in preservation. The key objective should be education by agreement for those affected. Do we lack the confidence in our ability to find agreement? I kind of think we do. When I read through this document, I say, oh, boy, they want anything but to get agreement from the citizens. This document paves the way for making every single nook and cranny of this city a historic preserved area of one kind or another. Now, maybe that's your key objective. Maybe that's why you were hired, Michael. And I suspect it is, and I suspect you're doing your job. But I'm not sure everybody in this city agrees that every single nook and cranny should be eligible to be a part of a historic district. And I've said often, and in front of this group, and all of our petitions start out by saying, we support the downtown historic district. We're talking about outside of that district. Protocol seeking consent based on reason is positive. I don't know how you could be more positive. Your own city codes 3.3.2 C and H provide in part the responsibility of this commission to educate. I was hopeful that you would take the opportunity in the rewrite to suggest that you are going to take that as a primary goal and objective of this committee and build in some real education based on agreement and understanding by the community. I don't think you really want to do something that we don't understand. Forest preservation is absolutely counterproductive. And I think that we lack the, I think we lack the will to do it in a very positive manner. I'd like to see people that are now objecting to anything this commission does to say, by God, they understand, they're moving forward, and they're giving me reason for their action. I mean, who can argue if you have good reason to present something? We were talking about fees. Did we get to fees yet? I think we did, didn't we? We haven't
We
gotten
did
there?
last meeting.
No, I'm talking about fees as it refers to the district, to the historic district.
We didn't talk about that.
Fees are included in the section.
It is included in
I'm
the
assuming
section.
you've reviewed it.
And we did talk about it last time, and I don't think there was real clarity in what was coming from this side of the room last time. I think, if you listen carefully, we were suggesting a separation of cost recovery and fees. I understand everything in there is a fee, and it's appropriate. Citizens shouldn't be saddled with unrecoverable costs once an application is made or when it is enacted, and a non-refundable fee, a non-refundable cost, I think, would be $500. $500 for a home that you intend to commit to historic preservation district. Now, it may be only 4 properties, but if you think about it, it could be the 144 properties. What financial reimbursement has been made to the owners of the Sunset properties? None, but they had some expenses. All deposits and fees should be set, it says in here, all deposits and fees should be set by ordinance. And I think that language is the same language as in our current ordinance, is it not? In our current code?
Correct.
Okay. Well, the minimum amount should be listed in the historic preservation section. As you can tell by my comments, I'm familiar with this code. I wasn't in 2011, and I wasn't in 2014. In August of 2014, I called 2 senior staff members of the city of Geneva, and I said, hey, I read the code, and it says it will be subject to some charges as set by the city council. What does that mean? How can I put a figure on it? They both said, look, it's in the historic preservation code. I said, no. And they said, oh. I said, I've read it word for word. It isn't there. It just says it can be there. How much is it? How do I figure it out? They said, I'll get back to you, Marty. August of 2014. Well, I didn't get an answer. 2014, but I'm sorry to say that's part of the course. So I guess in summary, I'd say, don't bury the fees, whether they're $10 or $1,500. Put an estimate so anybody that says, what am I applying for, can look and say, oh, they don't have to look and say, oh, I got to figure it out. I got to call somebody else. I need a lawyer to find it. It's not reasonable. Filing. You're asking for 2 copies, and I think that makes sense. I think 3 copies would make more sense, and make the 3rd copy available to the opposition.
Marty, copies of what? What are you specifically referring to?
Pardon?
You said
Under
2
filings.
copies, possibly 3 copies. Copies of what?
At the time of the filing, the applicant shall provide to the preservation planner a list along with 2 copies of self-addressed envelopes. I'm suggesting a 3rd copy of self-addressed envelopes.
The purpose
Third
of that
copy
is?
to be used by the opposition.
But we don't know who the opposition is.
What
at that
happens if
point.
there's
Don't use
multiple
it.
oppositions?
But when the opposition comes up in an organized group, it should be made available to them. It's a small point. Owner notice. Now, I heard last week that, again, we don't have the staff to be notifying the owners every time there is a suggestion. Well, if we have a historic district suggestion, I think you ought to notify the staff. The owners. And I think you ought to notify them as soon as an inquiry is made. And I think the notification ought to include who's inquiring. And I think the notification should go to the owners, to each and every one of us, and it should go to the aldermen. Now, I don't know why we elect aldermen if we don't elect them to be involved in the nitty-gritty of things as they get started. I don't know what the protocol is here of whether or not you're allowed to talk to aldermen or discouraged from it, or if it interferes with the mechanisms that I don't understand. But by God, I think as a citizen, I want my alderman to know if you get a call that says South Batavia Avenue should be made a historic district.
But your aldermen are part of those homeowners. They should be noticed twice. They live in your district,
That's correct.
so we're sending it out to everyone in that proposed district.
That's clever.
I'm
That's
just
really
asking.
clever. I think the alderman in the position of the alderman of the city of Geneva should be individually
Oh, all the
notified.
aldermen.
All of the aldermen.
Oh, okay. I didn't,
Well,
I,
excuse me. I do
I did
agree,
not
all of the
understand.
aldermen, I do agree, all of the aldermen.
Is-
But
is
the
that
2
part of
aldermen that I'm talking about are the aldermen that represent this district.
Right.
Now, it's fine to put them in a category of they're a homeowner, they'll find out along with everybody else. That notification ought to come directly from Mr. Lambert to those aldermen, and it should be immediately after he gets the telephone call. I think the notification to the residents should be as fast as humanly possible. And it is fast if upon receipt, you do an email blast, you put it on the website, and you let the news media know, paper and electronic. Now, why? Why am I insisting that you get this out? Because I think once you get it out, the pressure is on the applicant to come in with a positive response. I hope at that point, the applicant, whoever they were, would get the idea that, oh, they're looking for owner consent now, and now the word's out that I want it, I got to go out and get owner consent. I'm going to start my process of all of my contacts and all of my knowledge that I have. I'm going to reach the owners. And the educator here is going to say, I'm going to have a public hearing, and by God, I'm going to present it in a way that anybody sitting there is going to stand up, including Marty, and clap for having done the fine educational job. The public information meeting. Sounds more like a lecture to me. I think it needs to be renamed in some way. You know, that if it's what took place at the Public Works, that was an embarrassment. I was embarrassed to be part of it. And I think the city people that were involved were embarrassed about the way it was presented. Commission analysis, available to the public in advance of a public hearing. How many working days in advance? Here's something from last week. There was a gentleman that stood up and said, in a way that would suggest he was upset, we just got this. And you, Mr. Roy, said it was posted. Okay, well, I'm suggesting that when you have legal text available online with 50 pages of legal information that has been worked on with 35 years of experience for over 2 years and 100 hours, to put it online on a Friday night and then tell someone that it's online, you've had a chance to read it, that's unreasonable. That is just so unreasonable, I can't believe it. You did that on the meeting for the 24th. And I would hope that in the future that we don't rely on the fact that it's online, you have to read it over the weekend, or you have less than 2 days to absorb this text and then come before this commission. I think that is hiding fact. I think it's destructive to the way historic preservation is perceived. And I'm listening to myself and I'm saying, please don't accept this as an attack on this commission, because I have great respect after listening to the conversations that have gone on for the thought process that goes into not just this subject, but everything that you do. I respect this committee. I respect my rights more. I respect the fact that you should give us an opportunity to agree with you more than I respect your move to make it the other way, to move towards preservation based on people not descending from the process rather than agreeing to the process. That is just totally wrong. A minor point on page 22, everything shall be recorded and the appropriate county recorders. I agree with that. But I would ask, have we got the manpower to record our current district? I don't think it's all recorded. As far as I can tell, there's a lot of houses that have not been properly recorded. There's a lot of goals and objectives listed on the website that this commission has. That, I believe, was one of them. I'm going from memory from a couple of years ago. I don't think they've all been, so that's a question. And again, any work stop should be only that not supported by a previous permit. Rescinding the designation. I don't know if it's appropriate, but the first thing that came to my mind was that there's another way, and that's by referendum. I would financially support a referendum, and I would detest the fact that I would be forced to do that, because I think it would be destructive to other good works that are done by this committee. Does anybody have a question, or would anybody like to correct any of the statements I've made as incorrect?
Who wants to start?
May I just, so I can preempt any discussions that might occur between the commission, because there are some things that do need to be corrected. First of all, I want to get back to this business of the 51% objection and approval. You've referenced the sample ordinance from the Certified Government Historic Preservation Ordinance that's produced by the Illinois Historic Preservation Agency. What the language actually says, and I spoke with Catherine O'Connor today just to verify that I was correct,
As did I, not today.
and what the language actually says is that a petition with no less than 51% of the property owners, it does not say property owners objecting or property owners approving. All that the state sample ordinance calls for is that there at least be 51% of the district people being nominated, or 51% of the owners of the property within that area being nominated are included on a petition. It could be for or against. What the purpose behind that language, and it's been modified by many different communities, many different ways, and interpreted in many different ways. What the intent of that is to make sure that there is a majority of the area aware that there is a district being proposed, not for or against. So that's a clarification.
If their signatures are on an application, 51% are on an application, would that not mean that they are not only aware, but they're approving?
That is exactly what Catherine is saying, that all the petition requirement that they're identifying in the ordinance is that at least 51% of the area being nominated is aware that there is some action taking place. Not necessarily it's in support or against. Other communities have interpreted that differently, but that is what the intent of what the state's
Okay, well then, her
sample ordinance is.
interpretation of that has changed since I talked to her last year. I mean, there's just no question about
Well,
it. But, you know, I'm not going to argue with you. You have your position. I think your position makes some sense. Not nearly as much sense as educating, getting agreement, including agreement on the application before it comes to this committee and waste your time, and waste the time of those who want to dissent.
Just a few other things, and I'm not trying to be argumentative, I just want to set some of the records straight. Mr. Smircher says we haven't applied for a grant. We did apply for a grant this year, and we did get it. We have not been awarded yet, but
Through the state?
through the state.
The CLC? I mean,
Through the
CLG?
CLG grants, and we have a grant for commissioner training from a professional organization to go through the legal and the statutory requirements of what a commission is supposed to do to follow due process. So, and some of the things
That's a little different than education.
well, no, it's very educational. It's done by.
Educational for you. I don't know
But
how
if-
educational it'll be for me as a citizen.
Well, I understand that, but
Okay,
where education.
So one time in 12 years, we applied for a grant.
Where education begins is to make sure our commission fully understands what its responsibilities and roles
I
are.
support that.
And then we
Okay.
can branch out into
But we
being
got one,
educators.
we applied once in 12 years.
Well, I've only been here 2 years, so I'm just letting you know that we have applied.
And part of that issue has to do with Geneva budget, because
Pardon me?
the grant is to cover half of the cost.
Yeah, that's why
Yeah.
I started out by saying
So
you're
if-
underfunded.
So if our budget does, if the Geneva budget,
Yeah, so
can't
if you
handle
want
the
to,
extra
if you want
half.
to do all of this, include
Understand.
a recommendation to the city council to increase staff and to increase budget.
I have no control over that, so.
right, you can't comment on
So I
it.
can't
You
comment on that,
well,
really.
I think it's part of your job to make recommendations.
Well, and we do work through the department, and then recommendations are made as it fits in the whole scheme of the city budget and the city goals, so.
Somebody has that obligation, and it shouldn't be me.
And again, I want to stress that I know Mr. Smirchers doesn't like the title of it, but a public information meeting is exactly what is meant to be, is to provide all the information to all people at one time, so they're hearing the same thing, not what someone heard at the grocery store, at the drugstore, or at the park, or what have you, but all the information is being presented on all sides of the issue, the pros and the cons. And again,
Michael, I think it's obvious. The only reason I mentioned that is I wanted an opportunity to mention how bad it was in 2011 and to challenge you to do it in a more positive way and a more educational way going forward. That's my only point.
And I understand that, and again, you're not aware of my 35 years, but I've heard all different sides of how that meeting went, and it sounds very disturbing. I'm sorry that it was a disturbing meeting. I tend to probably do things a little bit differently in the way I've been trained. So, and that's no aspersions against anybody, but I have heard, since I've gotten here, about how that meeting disintegrated. And, I was trying to make sure I caught all your notes. And just to be aware, and David, correct me if I'm wrong, but none of the commissions set the fees that are charged. That is not something within our purview. That's the way the city government is set up. We can make recommendations, and we have through our department, and that does work its way, but it's ultimately up to the city council to set all fees in the city. So we have made recommendations, and we will continue to make recommendations, but
Michael, it is their responsibility. And if they should meet next week and say that we're enacting some fees through another department, I'm saying take that number or an estimate of that number and put it in the historic section. You're not establishing a new fee, you're just stating what the fee is.
The reason it's not included in the ordinance is so we don't have to go back and amend this ordinance every time the fees change.
We have to vote on that every time it changes.
It is enacted by ordinance,
Okay,
approved by the city council.
You
Please
guys are
let me,
really clever. Figure out a way.
let me finish, Marty.
I'm-
It is enacted
Figure out.
by ordinance by the city council, and then those fees are
It's not my
reflected on
point.
our applications.
That's not my point.
Just not in the
Figure out a
ordinance.
way that when I inquire what are those fees, I can get an answer.
And that would be the goal here, because when the fees would be clearly established by the city council, and then we would know what those fees are after recommending.
Do we currently have fees?
We currently do not, and that's why we have not been able
Oh,
to answer you.
I didn't realize
There
we
has never
do.
been an ordinance passed regarding
Excuse me, I
historic
did not
preservation.
realize that we do not have fees. And that's why we didn't collect anything in the Sunset Road situation in way
We
of
don't have a
fees.
minimum deposit clearly defined.
Okay. I
We
stand
have the
corrected.
costs that are to
I
be-
didn't realize that, but once they are, then it'll be easier for a senior staffer to answer my question when I ask them what is the current fee.
Right, and because we did not have those fees
Okay,
clearly
I
established.
stand corrected. I appreciate it.
Got anything else, Michael?
the only other thing I was taking a lot of notes, is Oak Park does not require owner consent. I just want to correct that. That is not true. Doug Kari, who used to be here at Geneva, he is the preservation planner at Oak Park, and they have not had owner consent. They've had, ever had owner consent required as far back as 2003.
Well, what do they have? Am I totally wrong that,
I don't want to stand here and say you're totally wrong enough, but
I called
on
you
Oak Park,
totally wrong.
you're not correct. They do not require owner consent, and they have approved 2 landmarks without owner consent in Oak Park.
So they've approved 2 landmarks without owner consent, and we've approved how many without owner consent?
Well, one began without owner
Right, but
consent,
we've approved none.
none
without owner consent.
correct.
Okay,
One
so
began.
they've approved 2 within how long?
Since 2000.
2000.
Thank you.
And I spoke to Doug Curry as well this week.
Okay,
You got
excellent.
some other
I
comments?
stand corrected on
Yes, I
that,
do.
but I have recently read the codes on the other cities that I mentioned, and they do have an owner consent. And I'm not saying any of them
Does St.
set a
Charles have
standard.
an owner consent for the
They do
district?
not. They do not.
Can I speak to that? Could we have some other people
Yeah.
speak at the
Well,
podium?
Well, I'm just trying to figure out exactly what is the truth. I mean, because if, I don't see an issue with, I actually like I think you're absolutely correct that it starts with education. And I think that all the organizations that are pro-preservation should be working towards education to get owner consent.
And that's part of the purpose of a pre-application meeting. It's the purpose for the public informational meeting, to get that information out there in a single source method. You know, if that information is presented and it degenerates into a shouting match, you're not going to get the information out. If a meeting can be held with decorum and order and get the information out there and let people make their own judgments based on all that information out there, then you have the chance to educate. And you're right, education is a big part of preservation. But it can't be done in a shouting format.
No, but I think,
That notwithstanding, I think that I agree with Paul in that there should be education, and I also like the fact that you have it codified here, exactly how that information is going to be disseminated, and how, and I believe that it's pretty substantial, you know, that you have the, you have the education of the notice, you have the education of the signs, you have the education of the informational meeting, you have the education of the public hearing. So, I mean, you've got multiple sources of education there. So I think that, I mean, I wasn't at this meeting that you're referring to, but, and to tell the truth, meetings can go south often.
Too quick.
But having it codified as to exactly how that occurs, I think I really like that aspect of this.
Well, may I say, I agree with that, but I've got to go back to the premise. Do you want to do this based on dissent? Do you want to set up a mechanism where you grab all of the dissenters and have them come out full strength? Or would it be better to grab all of those that agree and have them come to you in full strength
Yeah.
with agreement?
You're starting to repeat yourself. I wanted to try not to let that happen.
Yeah, I didn't want to repeat myself except where
Carolyn,
I
did you
thought it
have-
wasn't clear.
Yeah, I did want to comment. I did want to comment about the research that I did. I was on the phone for 3 solid days, talking with 12 community people. I was speaking with planners, planning division managers, director of community development of 12 different communities. 9 do not require owner consent for any kind of landmarking. That would be Highland Park, Oak Park, West Chicago, St. Charles. And in St. Charles, I talked to the planning division manager, Russell Colby. Long conversation. Lake Forest, Naperville, Evanston, who has 4 local districts with 1,500 buildings in those districts, Woodstock, and Batavia. 3 communities do require owner consent: Elgin, Aurora. Long conversations with both of their zoning officer and senior planner. And in Hinsdale, the director of community development did not want to talk about the ordinance because he said that they have lost many historic properties. So of the 12 that I spoke with, 9, many of which are local, many of which are poster children for historic preservation, do not require owner consent. However, every one of the people that I talked to said that they would very much like for owner consent. They would do everything they could to educate the person who would be having a house landmarked, or people in a district. But when push came to shove, that was not a requirement. Now, I thought what was interesting in Oak Park, they have had, as we've just heard, 2 properties that were landmarked over the owner's objections. One was with the library district that wanted to make considerable changes to the Mays Library and did not want to consent to HPC review, even though the Mays Library is in the historic district. And because of that, the citizens formed a group and started landmarking process. The library board agreed to the HPC review, and in the end, the building was landmarked with owner consent, but the process began without. Second one, 2005, the Village of Oak Park bought an apartment building, which was considered contributing in its survey, with the idea of tearing it down to enlarge a parking lot. Another concerned citizen group gathered together to start the landmarking application, which was approved by the HPC. However, the village council denied the application and the building was torn down. So I just thought those were interesting comments from my hours of research.
I consider myself corrected.
Right.
And the last
Can
one-
we give some other people a chance to
I'd
talk?
like to make one last statement.
Okay.
I learned early on that to look at what others are doing is not a proper excuse for your own behavior. And I think our behavior should start with approval rather than dissent. Thank you.
Thanks. You want to come up, Liz?
Okay, Liz Safanda, 1013 Dunstan Road. I'm not even sure where I want to start on this. I would like to make reference to the educational program the City of Geneva had 3 years ago at the City Building on South Street. I was there. I assume were several of you there on that occasion. As I walked into the building, 2 women came in with me and they said, "We can't wait to go in and yell about this. This is so appalling." I said, "What are you talking about? This is a public hearing." Carla Kalfas had brought a speaker up from the Illinois Historic Preservation Agency who gave an overview of what historic districts consist of. She then described the procedure that would exist in Geneva. It was supposed to be an informational meeting. I do believe that mistakes were made by the city in that they drew an initial map that I think was very faulty and it was misleading and kind of inflammatory. But on the whole, the meeting was structured as an information meeting. It lasted 3 hours. And during that meeting, I heard constant boos, yelling at the speakers. One man who was here last week in the audience, sitting back here, lives on Peck Road, stood up, and I had spoken earlier, stood up, and as he left, he waved his hand in front of my face and just about slapped my face. This was an extremely uncivil meeting. It was set up by the City of Geneva to be a civil educational meeting, an information meeting, not a public hearing, and it really did dissolve. And I was absolute minority at the meeting. So I do feel like the city, previous to Michael Lambert, had made that effort. Secondly, I don't like it when misinformation is given and he's reading a list of cities, which actually is not accurate. So fortunately, you knew that. And fortunately, I had done my homework and I've talked to Russell Colby. And I know the situation in St. Charles, which wasn't always an easy one because they had that big conflict with their house on the west side. And the city commission, which was going to put forward the designation against the homeowner's wishes, eventually did withdraw it. And I think they felt like they learned from their lesson. Don't go forward, really. Try not to go forward without owner consent unless it's an extreme situation. Okay, third point. Preservation Partners has worked on this issue since 1911. We have devoted much of our newsletter to this on occasion. We have sent out many memos on this topic, trying to educate not just our membership, but the general public about this issue. And with regard to that, I just have something I want to enter the record. I will not read it tonight, but one of my staff members today found a study online put out by the city of Tucson, and it's a study of situations in 10 states whereby the value of residential district designation for property owners is evaluated depending whether or not you are in the district or your property resides outside the district. I have read such a study in Rockford. It's a good study. It shows very much that the properties in the district have a higher resale value than the properties outside. I decided that is not really relevant to our situation. Rockford is a really economically impacted city, and so the historic district is very centered downtown, has a lot of federal and state funding, and is probably not a very typical situation. You wouldn't be surprised to hear the properties inside are valued more than outside. But in the 10 states that, and I'm going to pass this to you, Michael, to pass around. Is that okay to submit it? And I promise not to read more than a paragraph of it. But in the 10 states that were surveyed, they all showed, and they were from Arizona, and then like in Arizona, it was Tucson, Phoenix, Mesa. Mesa is a community that I might consider as comparable to Geneva. They showed property values increase by 5 to 35% per decade over values in similar undesignated neighborhoods. And there's a chart on page 3, which shows the 10 states that were surveyed: Georgia, New Jersey, New York, Memphis, Galveston, Durango, Denver, Athens, Georgia, Tifton, Georgia, 9 cities in Texas, Savannah, Georgia. So I just want to put this in the record because I think when this comes to city council, they do want to know, we've kind of tossed this figure back and forth. They do want to know, is there an actual economic value to being in a designated district? And while we were online today, my staff member and I looked for a number of other studies. We could not come across one that gave contrary information. And by the way, did I give you enough copies there?
Yes.
Okay. The last statement from this. Okay, here we go. That I want to quote: "The results of these studies are remarkably consistent. Property values in local historic districts appreciate significantly faster than the market as a whole in the vast majority of cases, and appreciates at rates equivalent to the market in the worst case. Simply put, local historic districts enhance property values." And so I consider this a little educational interlude here.
All right, thank you.
Okay? Thank you for listening.
Someone over here? Someone over here want to speak? Can we give some other people a chance? Okay, thanks.
My name is Jim Couts, 1305 South Batavia Avenue. I think this is just an appropriate time to do this. There's just a short piece I'd like to read from a Geneva resident who couldn't make it tonight, and that is John Ford. He is from 805 Forest Avenue. This is to the Historic Preservation Commission regarding the renewal of the historic ordinance. I'm in favor of retaining the part of the ordinance which allows a non-owner to nominate for landmark status. As I approach the selling of my house, I'm reminded of the reasons that I bought it 37 years ago. Among the leading reasons were its neighboring properties and neighborhood. They were and remain a principal element in my long stay here and of the value to the next owner. Neighbors have a vested interest in each other. Remember the rule of thumb for housing: location, location, location. Thank you, John Ford. And I do think that it can be rather convenient to be living in a town like Geneva with the benefits that have been provided to us by the historic district. The fact that the businesses and the homeowners who live there seem to thrive and enjoy their time there, yet for those of us that don't live in it, in the district, we get to enjoy all the benefits, and it is rather convenient to say, don't you ever do it to my own property, because I just like it the way it is right now. Thanks.
Thank you. Someone else? Okay.
Yes, I'm Sharon Jones, and I live at 521 Franklin Street in Geneva. And I'm just following up here on Jim's comments here because I want to thank all the work you've done, Michael, on this. I really appreciate it, and the support that the council and your commission has given to work on this. And I live in the historic district almost 40 years now. I love it. I absolutely love it. Just like Jim talked and John Ford referenced. Not in the district, John Ford, but me. Gosh. It just gives you such a sense of place and connect with the history and where you live and all these links. And as far as value goes, I'm just shocked at the 4 homes that are going in, where there was 3 homes, where there's going in one ranch by 6th Street School that was torn down, the one ranch, and there are 3 homes right behind my house now that I now look at instead of one. I tell you, my husband and my property value is going way up. If they're spending the money that they are on these homes, these narrow 60-foot lots, the desire to be in a historic district is just huge. The assets are tremendous to be in a historic district. And I love it, and I've loved it for 39 years, and I hope to stay here another 10 years. Thanks.
Thank you. All right, you got a comment?
Hi, Chris Bordage, 40 South Lincoln. I didn't want Marty's voice to be the only one dissenting. I, too, think that everything should be going forward on a positive note, that there should be, you know, a coming together of owners wanting to be in a historic district. I purposely bought my house outside of the historic district because I shuddered to think the hoops I would have had to jump through to do the renovations that I did on my house. My house, I think, came out beautifully. I love it. I own it. I put the finances into it. And that's what's important to me, is that that's what I have. And I'd prefer not to have my house swooped into a historic district if I didn't have any say in it. And if my neighbors, if 51% of us didn't agree to be in that historic district. Because I think it's somewhat like having a swimming pool. You're going to get buyers that love and want to be in the historic district, and I think that's terrific. You should want that. But then there's that other crop of buyers that are like me that say, I'd prefer not to have to jump through all those hoops.
Right.
So I back up what Marty said, and I just didn't want him to be the lone voice that you heard.
Sure.
In regards to that. So I also don't agree with the 2/3 being able to override 51% of whether it be objection or, pro for it. I think that the owners really should dictate that and say, we want to be a part of this. So as far as having 2/3 of the commission override that, I don't think that's good language to have in there. So I'd prefer if you're taking suggestions, if that's something that can be eliminated from that, I think that would be an appropriate thing to do.
Okay. Yeah, it's actually 2/3 of us and then 2/3 of the city council too. So there's two different layers that have to go through to make that happen.
Okay,
So
thank you.
I appreciate you talking.
Can I comment about the hoops, please?
Sure.
The business about the hoops. It's something I hear all the time, that coming before the HPC or coming to Michael's office is such a hassle. Well, according to this chart that Michael put together for our education not so long ago, since 1995, there have been 1,115 applications for building permits. 0 were denied by staff, and less than 1% were denied by the HPC. So I don't think the hoops are excessive, and I don't think the outcome of jumping the small number of hoops, which really is based more on zoning than it is on historic preservation issues, is something that should be a concern for anybody who is not in the historic district.
Well, I guess in opposition to that, I know that I have family members that built a new house in the historic district. And when they came before the commission, there was roof pitches that they wanted changed, there was windows that they wanted changed. So that to me is hoops. So maybe our definitions are different, but if I come up with a house that I love on a property that I've purchased and I'm going to put all my hard-earned money that I've saved into that house, I would prefer to be able to do that with just the permits that the city is giving me to do that, rather than having a lot of opinions of something that everybody is subjective on as far as what they think beauty is.
Well, I don't think we discuss beauty, do we? Is that,
Do we,
do we
Well,
have
roof
beauty in our-
pitches,
in our codes?
windows,
we stick to the ordinance?
Michael, you
I would just like to clarify one thing, since we are being recorded and this is a public meeting, is that one of the things that I think is very challenging for the Historic Preservation Commission and for petitioners alike is to realize that while some things come to the Historic Preservation Commission for review, because this is the logical place for it to be discussed, there are actually things that come out of the zoning ordinance. I think when you're talking about building heights and roof lines, and things that have to be modified, that's the tear down infill regulations that are part of the zoning. It does come to this commission for discussion to make sure that new infill is matching those zoning regulations, because we can't do anything at this commission that is counter to what the ordinance provides. So, yes, there are times that this commission is the one who's having to deliver the news that a building may not meet the tear down infill regulations, but that's not because of some subjective or some ulterior goal here of the Historic Preservation Commission. That's something that's been talked about in other parts of the city government and this community development department as to what is appropriate for the mass and scale of the community. So, and it's something when we talk about education, I mean, when people sit down with pre-application meetings with me, that's one of the things I talk about. There are the historic issues we talk about, but there are these other issues that the Preservation Commission needs to deal with because we're the body that the whole project is coming forward to. So I just want people to understand that while there may be the perception that the commission is requiring certain things, we're actually enacting other ordinances and regulations that exist that we have to take into consideration with the discussion we have. So I just want that to be very clear that, I don't think in the 2 years I've been here, anybody has asked for a roof to be lowered or a major mass being changed that was not impacted because of the tear down infill regulations. So just
That's fair, and I guess I just would prefer, I'm happy that I purchased outside the historic district, because I preferred to have things approved by, the building commission, rather than having to go through, additional requirements. So that was my only point, was that
the tear down infill is through the regular building department. You'd go through the same thing with that.
Right, that's true. But like I said, I bought outside the historic district with purpose, so.
Sure. And that's good. We're glad that you're here,
I'm glad I'm here too.
whether you're in the district or not. Yeah, Colin.
Colin Campbell, 18 South 6th Street. Two things real quick. One, yes, we would all like to have exactly what we want, but we live in a community, and living in a community is a contract. If you do something to your house and you live next door to me, you affect me. I've got rights too. And that's what your job is to balance those things so that the community is protected. You know that, but I just want to say it. Number two, I've been involved professionally in community education 35 years, not in the field that you're talking about tonight, alcohol and drug abuse prevention, alcoholism treatment, so on. In 35 years, I probably spoke to 250,000 people. Community education is not simple. It is very difficult, very demanding, very costly, very labor intensive. And then, after all that effort, you find that a great many people don't want to hear you anyway because I believe what I believe, don't confuse me with facts. And so it's easy to come up here and say, well, you need to do more community education. This entire commission could go full-time on community education on this issue, and you might make some headway, or you might not. So it's not a simple process. Also, in this idea of what can you do to a house in the historic district, you guys know this, but I just want to mention it. Gary and Betty Parker's old house, and I don't know the couple who bought it. It's on Campbell Street, no relation, between 5th and 6th Street. Historically plaqued, significant contributing house. The couple who bought it wanted to renovate. They worked with this commission and the city and stripped that house literally down to the studs and rafters. Took everything off. You could walk by and see through to James Street. They renovated the inside by moving the walls around. They completely put in new plumbing and electrics, brought it up to absolutely new standards, refinished the outside of the house, added on an addition behind the house with a two-car garage and a two-story addition for bedrooms, office, and living room. And not only did they not get rejected by this group, they got an award for the city, from the city for historic preservation. People simply don't understand how much you can do if you do it properly. Are there regulations? Yes. Are there building codes? Yes. Are there zoning codes? Yes. That's part of the contract, living in the community. Thank you.
Thank you. Any others? Yes, come on.
I'm J.B. Tursich, 946 Sunset. This is my lovely wife, Jennifer. I am so sorry that I've not been able to make the previous meetings, just due to my travel schedule with work, trying to balance 5 wonderful kids. It's been a little difficult. 2 points of what I read, and again, I just breezed through this tonight. I've met Michael before. The fee thing, I would love to know what you guys are recommending to the city council, because I think that is a big, big deal. Okay? If it's $5, you guys are going to have a runaway train. It's going to continue. It's never going to stop. You got to get something with some teeth in it. Okay? The second thing is, if somebody's going to nominate a different homeowner's home, okay, and it happened to me, if you don't do it by certified mail, don't do it. Okay? I was up and forthright. I came to the village. I said, what the heck is this? This is crazy. I would have never bought that house had I known what could have happened. Okay? However, once I did, and I spent $685,000 to try and renovate a house for my wife and 5 kids, one who has special needs, to find out that I spent 6 months and a ton of extra money to basically be told by somebody who had no bearing, who didn't understand one damn thing about my family, why we moved here. By the way, we lived in Mill Creek, okay, for 16 years prior to that. Longer than the person who brought the nomination to me. I've been a Genevan for 18 years. My oldest son is 18 years old, and the 5 below him have all been part of Geneva, okay? I don't know who can say they have more roots to Geneva, but as far as that goes, we have roots to Geneva, and we have reasoning why we wanted to move to the downtown district. With that being said, the number one thing we found out was that we were not in the historic district, okay? I have lawyers too. I paid people to do the research and do all the due diligence before I was going to go and outlay $685,000 on a house, okay? And if anybody was sitting here and were in my shoes, you would be as upset and had as much disdain for the whole process of somebody being able to nominate somebody else's house. I understand the historic thing. It's what makes Geneva have the charm. It's quaint. It's lovely town. We love it. Okay, that's why we're here. Okay, but as far as being told what you can and can't do after the fact, I'm just going to tell you guys that is simply wrong. It is just flat out wrong. Okay, and if anybody else were in my shoes and didn't say it the same way, I'd have to tell you there might be a screw loose, because it's not the money. This is an emotional thing. This is about my family. This is about having my special needs son being able to walk to downtown. Okay, he's going to be with us, God willing, forever. Okay, that's a big deal. Mill Creek is 5.5 miles away one direction. It is not easy. Everything you do requires a car. Okay, there is a big deal with that. And if anybody can also tell me that my house that we built is not as architecturally significant as the previous yellow house, I would have to tell you, with all due respect, you might need to get your eyes checked, because we've done a great job on that house. Okay, that's all I have to say.
Thank you. Yes.
Jeff James, 825 South Batavia Avenue. Just trying to get clear here. It seems like I came here for 2 reasons. One was the building permit, which I think made sense, right? The second one was the 51%. and I don't get a feel for it. It seems like the 51% people for it is a no-brainer. Is there opposition to that from the council here? 51% being on the positive have to agree to it instead of the other way around. To stop it, you have to have 51. Am I wrong there?
That's what it currently says. Are you asking us to give our opinions?
Well, I'm trying to get a feel for, because you said that the best I heard you say that it was, it could be interpreted either way by the state, it just had to be 51% aware. I think we all agree, right, about the 51% for it. The homeowner should be for it, to have it move forward. But I guess the way it's read right now, it's 51 have to oppose it, to stop it. Is that accurate? Did I get that right?
Actually, again, what the state's,
What does your document say right now?
It's not my document, it's the document I'm presenting for this commission to
Okay.
decide, but just so you know.
You're the author of that
What I've
document?
authored.
Are you
what
the
I've-
author of that
yes,
document?
what I've authored,
Okay.
after a lot of research, is following consistent with our zoning ordinance. It's a 51% has to object. And that is consistent
Okay,
with, correct me if I'm wrong, but that's
okay, I
consistent,
understand where you're
consistent
coming
with our
from.
zoning ordinance, and it's also consistent with the recommendations of the Illinois Historic Preservation Agency.
You said that was interpretive somehow.
No, what their sample ordinance says, it does not clarify. When you talk to Catherine, who is the local government services coordinator, her position when she advises communities who are working on historic preservation is to request or require a 51% objection clause.
Let me tell you where I'm coming from on this, right? I've been a resident 18 years now, came from Batavia, so I know the area really well. I came here, it's a beautiful town, we came for all the same reasons, right? But I came into a district and I bought a house for 280 grand, but I'm telling you, the barbed wire fence around, it's been abandoned for 15 years. I pulled out every stinking ring nail out of that thing by hand, some thousands of nails to pull up the plywood to get to the floor and do all that work on it. I was rewarded by going from 9 grand taxes to now $24,000 a year. That was my reward for making it good. And now I come here, and now you want to give me more taxation? Because I don't care what you say, I don't care about all these other states from around the country. I listen to the real estate people, and they're telling me a different story. And I'll tell you what, I think I'm pretty good at my design work, and I think you look at my house, everybody would say, hey, it's a nice house, whatever. It's much better than it was before, just like the gentleman before me. And have somebody stop me and tell me that you're going to tax me and you're going to have some better idea how it looks than me? Well, I got to tell you right now, guys, you're barking up the wrong tree. If I moved into an historic district, okay, I take on, what comes with the territory. But if I have my own line, I put that house is my investment. That's my retirement, okay? And the county is stealing my money out of my pocket every year, and it pisses me off because it's wrong. It's damn wrong. And to have somebody now come here and tell me that they don't like the way I'm doing something, well, kiss my ass. You put a sign in front of my yard, and you're gonna have to fight me off, okay? Because that is wrong. I don't care what you guys think. It should at least minimally be 51% we agree to it. Not somebody come in and try to have to jump through some stupid hoops to try to fight it. Be positive, guys. You want to come in and fight? You're going to fight. You want to come in a positive manner? You be positive. That's all I can say.
I want to, are you under the impression that living in a historic district has increased taxes? That's what I heard. Is that what you think?
You putting the onus on me to do things differently than I do them now? Yeah,
wait.
that's putting taxation on me. If I want to pull those windows out of mine, put in Marvin dual pane windows, and I want to pull out those window weights because I don't like the way they work.
But you're not talking about literal taxation. You're talking about a perceived taxation.
I think everybody would agree, it will cost me more money.
But you're not actually talking about actual taxation.
I'm talking about your taxation. It'll cost me more money to live there.
Our taxes are higher in the historic district. I'm trying to understand it. You're saying that because you live in a historic
Is
district.
it literally a tax from the county? No.
That's
Is it
what
on
I'm
my
wondering.
tax dollar? No. Is it an increase for my ability to live there, cost me more money? Yes. I call that bureaucracy taxation. I don't care how you want to look at it.
Okay, I'm just clarifying.
I understand.
Thank you.
Just to clarify that, what Mr. James has said, that is one reason why there's the tax assessment freeze that's been put into place. Recognize that there is an additional cost to doing preservation sometimes, and that tax assessment freeze has been used very, very successfully here in Geneva multiple times, so it has been taken advantage of. And what that program is, for those of you who don't know it, that freezes your taxes for 8 years. If you spend 25% of the value of the building, not the property, but the building itself, and you follow certain guidelines, your taxes are frozen for 8 years and then progressively brought up to the regular taxation rate after 4 more years. So it's essentially.
I'm sorry, you said taxation, what, 25% you got to put into the 25% of the
So-
value of your home?
Right, so for
And you got it
instance,
frozen for 8 years? 25% of an $800,000 house?
no, what you bought it for. So you bought it for what? What?
Oh,
Let's say you
so
bought it for
mean what I paid for
$250,000.
it from day one?
No, not what, no.
20 years ago?
25% of the value of the building, less the land, or the property less
Building,
the land.
the way the county's assessing the building, I'm assuming, right?
When you bought it.
No, when you're assessing it currently.
No, it's 25% of what the purchase value is. You have to spend 25%.
Is today.
No, at the time of purchase.
So
At the time of
it's
purchase.
frozen.
280 grand.
You could have frozen
15,
your house
18
at the
years ago?
$250,000 mark.
I just want to understand.
If you lived in the historic district, which we know you don't, right?
Well,
Or
that's
do
what
you?
this is all about, right?
Right.
You're trying to.
You don't live in the historic district. So
Madam
you,
President.
let's say you bought your house at $250,000. Let's say $200,000 to make it
Whatever.
easy for math for me, because it's been a long day. So if you spend 25,000, no, 50,000 into the house, then it's frozen at the 200,000 mark, despite the fact that it's now worth 800,000.
Okay, so we're clear.
Oh, and that's for
I didn't
10
understand the way
years.
the tax law worked.
And that's for 10
That's
years
not
with the
current value,
graduated.
that's-
Your
purchase value.
Initial
Purchase.
purchase.
What's your purchase?
So you could have saved all those taxes had you been in the historic district.
Okay, thank you.
And I believe that we do have several cases where they in fact did that.
Yes, there's several pending right now.
All right, any other comments? Are you gonna just comment on some of the other comments that we've made? Come on up.
I'm going to try not to be too redundant. Well, I'm not going to be redundant, period.
Okay.
If you go to page 18, at the bottom of the page, it says, "Any geographic area composed of 2 or more properties and listed in the National Register of the Historic Places may be designated as a local historic district subject to public hearing."
Right.
I'm wondering if that is complete enough. I'm wondering, is it also subject to an application? Is it also subject to this commission approving it?
It's,
Is it also subject to the city council approving it? Or is
it
it
is all-
only subject to a public hearing?
no, you follow the same process in the ordinance, whether it's 2 houses or 200.
And what that sentence is, what that is getting to is, there is a pretty strong debate, and it comes out of the IRS actually, about whether or not a building that is getting an honorary designation as a National Register property, which that's what it is, it's an honorary designation, versus a local property that has protections and incentives associated with it, whether or not it should be an automatic local landmark. And what most communities across the country have decided is that those 2 programs need to be kept distinctly separate, so that one is an honorary listing, and the local is the one that does have more protection and more regulations necessarily associated with it. So all that's saying is it was silent in our current ordinance, but we're saying just because you're on the National Register doesn't mean that automatically makes you a local landmark. You have to go through the public hearing process again. And the purpose behind that is to educate the owners as to what they're agreeing to as a local ordinance, as a local landmark.
I think that's good, but the way it is put in here, at least it generated a question. Was it subject to all the rest of it? So a little bit of language smithing there might clear that up. On the tax credit, I wish we had had the opportunity that I asked for over and over to sit down and discuss it with you. I either misunderstood the tax credit or maybe it isn't clear. I understood the tax credit from the state or from the county for freezing your tax was based on the assessed value. The assessed value today on my house, if I wanted to get that 25%, if I wanted to spend the 25%, number one, I'd have to spend it on the exterior. So I've got $1 million house.
No, it doesn't have to be the exterior.
That's
It
correct?
does not have to be the exterior.
You can spend it inside.
Sure.
Yes, if it's in the historic portion of the building, it can be interior or exterior work, as long as it comes to a 25% total of the value of the property, of the building. Less than
What
that.
is the value, the assessed I have an
The
assessed
assessed-
value on my property right now today, which is higher than when I bought it, not too much higher.
It's the assessed value at the time that you undertake the work.
Undertake the work. So somebody that is living in a house now that is assessed at $500,000, even though they paid $100,000, and now they want to do the work, it's based on the 500.
Correct.
Okay, and you can go ahead and get a county tax break for work you do on the interior.
Work on the interior that is part of the historic property, so you can't have an addition that was put on in 1980 and include that work. That would be excluded. And it has to follow the Secretary of Interior standards.
Okay, thank you.
Right.
That's
you.
it.
All right. Any other, okay, you want to summarize your comments? We still have to talk about conservation districts tonight. So come on up.
Okay, I'll try to be real quick on this. So in the two hearings I've heard, and also in the meeting I went to 3 years ago, there's a lot of fear from some elements of the community about the possibility, this threat of their house being designated. Okay, I just don't see the threat being there. Situation on Sunset Road was a very unusual circumstance. Michael was new. Many of us were out of town for the summer. The person who did this unilaterally without pulling in support, very unusual. I just want to say that as head of Preservation Partners, and I've been in this job for 29 years, I practically could salivate at the houses I would like to landmark on Batavia Avenue. Marty Smersage's house, I would love to landmark it. Madeline Ross' house, I would love to landmark. I would love to landmark the Jacques Brownson glass house. I am not going to do so because these homeowners are not ready and do not wish this, and there is no reason at that point to go ahead and engage that. I do not see people, if I'm head of a preservation group and have a passionate interest in that glass house over there on Batavia Avenue, but I am not going to defy Charlie Bauman and his mother. So, what I would try to do is convince, but I do not see a real threat in this community that we are going to have a random, without merit kind of landmarking, besides that very unusual situation, like the perfect storm. But even there was protection. The fees were set as being so high that person pulled back. If she had gone forward with the application, it would have gone before the Preservation Commission. They might well have rejected it as not having merit. The City Council might well have rejected it. You have now added 3 more layers of protection to people who are concerned about that. You're saying there will be much faster notification, which is, of course, important, very important. And you have also put the 2/3 requirement. So I don't really see a risk. And on the other side, we have this tool in our preservation toolbox. And that tool should really, I had a letter from Fred Zinke before you were appointed to the commission years ago, saying he had this work in Oak Park. He said, you don't want to use that tool. You don't want to defy people unless it's absolutely necessary and you have a really, really critical situation, like the library in Oak Park, like Riverbank Laboratories. Just drive down the street, subtract that whole property from your visual landscape, and you will see what we would have lost that without any question at all if we had not defied the 3 men who were the trustees. So I really don't see see this. I think you've added layers of protection both for district and for individual, and I think that the incidence of people coming forward to making landmarking just frequently or random or without owner consent is just so minimal as to be disappearing, really, in fact. And I really think we should stick to reality. You all have so much to do, we all have so much to do. This is not one of our major risks here. Thank you.
Thank you.
Sure.
The reality, whether it was a perfect storm or not, I can't tell you. But I am the only person standing in this room that lost probably $10,000 on it. So money is real, okay? And again, that's an opinion, and whether it's a perfect storm or not, I'm not here to, agree or contest that. But I'm telling you, money will talk. If people are really so up in arms about trying to do it to somebody else's home, I'm not saying extending the historic district. That should go to a vote, and the public will be heard. But if you're going to be able to go and nominate somebody else's home, the city better be ready to defend themselves, because I was one that was going to be suing the city, okay, personally, and I would have spent every dime I had, okay, and I would have gone after Miss McNamara if I could have. But the city was protecting her through this ordinance. And I'm just going to tell you guys, it's a slippery slope, because I'm not the smartest guy out there, but property rights are a very, very, very dangerous thing. That's all I'm going to say.
All right, thank you. Any concluding comments before we get to conservation districts? All right, let's talk about conservation districts. Item 10.6.8.
Conservation districts, this is a new section that reflects current language in many historic preservation ordinances. This additional text reflects a recommendation that was made to the City of Geneva back in 2002 when an area of the city was studied for potential as a historic district, and the properties were found not to meet the standards for a National Register district. So the consultant did recommend that area be considered for a conservation district. However, the ordinance didn't provide any mechanism to enact a conservation district. So that is what this section is attempting to do. The concept of a conservation district assists in the rehabilitation of areas that may possess unique historic properties but may not meet all of the standards of a historic district. The establishment of conservation districts allows for the improvement of an area over time that may result, does not have to result, in that area or a portion of that area qualifying to be a designated historic district. Once a conservation district or portion thereof has met the standards of historic district designation, all or part of the conservation district could be designated, but it would have to go through the same process as historic district designation. Importantly, all review within a conservation district is completed administratively and is to a less restrictive standard than as a designated historic district. The format of this section reflects the formatting of the landmarks and historic district procedure. I can go through the individual sections if you've read that and you don't want me to, but I can go through and just highlight the individual sections, but it does mirror what we've looked at for both landmarking and historic districts. It's just the standards are less intensive.
Do we need to go through each point, or if people read it?
The only comments that I have would be the 51% of property owners declaring the same language that we decide
So if
upon.
we solve it on the district, then.
If we solve it on the district, move it to this portion too.
Okay. Any other comments?
Yeah, I found something in the construction plan review that said there are circumstances that HPC could review a conservation district project. Are those reviews using lesser standards? In the construction plan review, there may be things that are warranted at a high level that would have to be reviewed by HPC. That was listed under Conservation District. Let me tell you where it is. It's number 5, page 33.
Isn't that in the next section?
Well, yeah, but it actually refers back to this.
It refers back to this? Okay.
If at any time the preservation planner believes a project may warrant a higher level of review, the preservation planner may refer a project to the Historic Preservation Commission for review. And that's reviewing work at a property within a conservation district.
Correct.
So that means that we would have to review something at a lesser level?
Yes, what you're looking at is, in a conservation district, for instance, synthetic siding would be permitted in a conservation district, where it would not be permitted in a historic district. So you may be looking at and saying, we understand that the person is either adding to or replacing synthetic siding. The question might be, can it be installed in a way that doesn't harm the building any further? There are ways to install vinyl siding that doesn't knock off decorative trim or saw off window sills or things like that. So typically, and this language is coming out of several national models for conservation districts, and I have lots of information on it, but typically the idea is to, and we've talked about the word education a lot, is to educate people about approaches to rehabilitate their property so they're not destroying it in the process. Cases that would come to the commission generally are where an applicant may disagree with what staff is recommending. So it's giving them a broader audience than a single staff person to express what their goals are and how those may or may not conflict. It's in the same process, if you look at the conservation district, that while things are approved administratively, there is an appeals process. It's a two-stage appeals process that would allow any decision that I or any future planner would make in a conservation district could be appealed to this commission for a broader interpretation. And if they still didn't like the interpretation at the commission level, it could be appealed to the city council. But again, we're looking at the idea of a conservation district, and again, the area that was studied in 2002, the primary problem with that area for meeting the National Register standards was the amount of vinyl siding and replacement windows.
Okay, well, I guess that's one of the things too. I mean, if we're supposed to be reviewing by Secretary of Interior standards, in this case, you're saying they're reviewed on a lesser standards. Should those standards be made, more clear? I mean, is that something that future has to be added to this thing, or?
Actually, there was a very good article that I was reading today about the evolution of the Secretary of the Interior standards. The Secretary of the Interior standards were originally meant to be a very broad interpretive set of rules. What's happened over time as lawyers and local commissions and everything and local city councils have dealt, they've become increasingly more prescriptive in trying to identify every single detail. What the standards say actually are pretty broad. It says that you use sensitive materials, you don't destroy or remove historic elements of the building. So when you really look at the SOI standards, it's a very broad leeway where you get into issues again with using the Secretary of Interior standards and trying to evaluate against the National Register standards, is that the National Register says you can't have synthetic siding, you can't have the majority of your windows replaced, you can't. The National Register is what lists all those, a lot of times, all those things you can't have to get the benefit of being listed in the National Register. The Secretary of Interior standards is much broader. It's just over time, everybody's tried to define it and redefine it and redefine it and slice it so tightly so there can't be any mistakes made that now everybody kind of interprets these as a whole list of things you can't do. And and the standards really are very broad.
So would that somehow be defined so that it would be understood that these are much broader?
Yes, what would happen is, if this section's approved, is we would come up with a conservation district checklist, just much like we've come up with the permit table for within the historic district for designated properties. And so that would take some time to evaluate that and say, if there's existing vinyl siding, do we allow them to repair it? Do we allow them to replace it?
Would that be done only in the instance that we actually have a conservation district?
Correct.
Okay.
Correct. I think that's something that, again, there was the request. I will say I did get a call this week after someone must have watched 3.5 hours of us last week. And I did get a call asking a lot of questions about a conservation district because they know that their area is not, where they live is not going to meet the National Register
So
standards.
this section is almost a placeholder because we actually don't have a conservation district.
Correct. Correct. And that was the problem in 2002 when the consultant recommended a conservation district. There was no mechanism to follow through on that.
Okay.
Are there any tax advantages to a conservation district, or is that something
No.
that doesn't?
If you're in a conservation district, and I believe I have this correct. If you're in a conservation district and you're a significant building and you intend to rehab the project to, to follow the Secretary of Interior standards, I believe you can apply, but it's not it's not, I think it's up to the state to evaluate whether or not they approve it. I will check on that to make sure. I wanted to talk to Anthony Rubano on that, and I did not get a chance to get in touch
So they
with him.
could do the freeze?
I believe they can do the freeze, but it's under some certain circumstances. They definitely have to be rehabilitated back to a higher standard, so you couldn't leave synthetic siding on it, even if it existed, for instance.
Would there would be nothing to prevent a house in a conservation district from also being a landmark, though?
Correct. And there are many conservation districts that have a landmark. In fact, some of the cases that I was looking into, and when I was researching this, there were cases where, say, in a fairly depressed neighborhood in some communities where there's an outstanding one or two landmarks and the rest of the neighborhood is kind of degenerating, they have done a conservation district to slowly use as an educational tool as people are spending money to rehab, that, again, it's being done in a sensitive manner so that it's not destroying the neighborhood any further and helping those landmark quality buildings within the district. It's been used very successfully, most successfully in Texas. Texas has quite a elaborate program with conservation districts. It's been used in Minnesota as well, very successfully. But what it's been has been an educational opportunity to really kind of sit down one-on-one with staff and talk about what their building entails, what is historic about it, what is not historic about it, and because again, many people in conservation districts or areas that become conservation districts haven't bought into a historic district. They just happen to have an old home, so there again, for instance, our window policy that we have probably would not be appropriate to extend over into a conservation district, in my professional opinion.
So other than windows and vinyl siding, are there other issues?
Well, again, while the mass of the building would be governed by our tear down infill regulations or zoning compatibility, the additions could be put on potentially at parts of the building that would not be accepted in a historic district. There are examples of conservation districts that have additions to the front of the building. But they're done in a way that they could be removed in the future or altered, or they could be taken off and the space could be returned back to its historic character. There are cases where there may be a slate roof or a clay tile roof, especially in some of the areas in Texas where they have allowed if a clay tile roof is deteriorated, not forced them to put a clay tile roof back on, but to look at an alternate material that is not going to do any further damage, but is going to protect the structure.
So there wouldn't be any requirement to put a hugely expensive tile roof on a piece of property when the roof has failed?
Correct.
I see. Thank you.
That's an option.
As an option.
So basically, this is just one more tool in the toolbox.
Correct.
Okay. Other comments?
It just sounds like some of those rules seem a little too subjective. I mean, it seems to need to be spelled out a little more clearly. If I were a homeowner in a conservation district, I want to know a little more clear what I could and couldn't do, I think.
Well, that would be the next step. If this was adopted, we would go through the same process we went through with the permit table that we did for, the permit review table that we did for historically designated property. We'd come up with a similar matrix for a conservation district. But until we have one, I'm not going to,
Right.
promote or
Waste of
put the time into promoting something to you.
All right, other comments? Conservation districts?
Just one last, on page 30, standards for designation, part 2, are at least 30 years old in whole or in part. Did you mean 30 or did you mean 50?
I did mean 30. Again, one of the reasons for that is, remember I mentioned last time that the current Geneva ordinance calls for 30 years.
Right.
Typically, a lot of conservation districts around, or many conservation districts around the country, may be some of those emerging architectural neighborhoods that really haven't attained historic significance in the majority of the people's minds and memories. But there's becoming a recognition for that. It's very interesting. As some of you know, I teach part-time, and I get, some of my students ask all the time about what the 70s were like. And I'm like, I try to forget them. But to the generation that's 20 years younger or more than me, 30 years younger, the 70s is very novel and what have you. So it's hard sometimes for people who've lived through those generations to recognize an area as becoming historic, yet younger generations oftentimes bring those to our attention.
That's definitely true.
Any comments from the public on the conservation?
I did have one thing I did want to bring that I did forget to mention in my overview. Also, following the recommendations from the other areas, I have required a pre-application meeting in my internal draft that I have added that section in.
And you are going to change the suspension of work to be a permitted suspension of work?
Yes,
That it will not, if it's permitted, it won't be suspended. Is there even a reason to do that in a conservation district? That, because it's just during the period of filing, I mean, would that, if it's not as high a bar, couldn't things go on during the time that it's being reviewed, or?
It could, but I don't think you'd want to have happen. I'm not sure if you were on the commission yet when we had the siding issue up in the north side of our historic district where someone started replacing siding over the weekend and what have you. We wouldn't want someone to invest a lot of money in something that wasn't going to be appropriate, so that's why the suspension of work until the whole program is clarified. Then the building department knows exactly what's been approved, what have you. Again, because it's an administrative level, it's probably happening within a week to 10 days, at the busiest time of the year, maybe within 2 to 3 weeks. So it's not a long process, but the building department, it's good for the building department to know what we're looking at as well. So it's amazing how many eyes are out there reporting back to me what's going on in different parts of the city.
Take it to the public? Sure, come on in.
Madeline Roth, I live at 520 Ray Street. I would just like to take this opportunity, if I could, since I have all the appropriate people here, to mention a building I own at 610 South First Street in Geneva. I love this building. It was built in 1950. It's a flat roof, it's modern, has a great feeling to it. It's where my business is, and I have a tenant. You're going to make that into a parking garage, and, no matter what, this was a few years ago, and this went on the downtown's, I don't know what you call it, your comprehensive plan. And so I'm sensitive to this. The city is going to take away the building. I don't know when either. The building needed a new roof. I couldn't decide, do I do the right thing and put on a roof that will last 20 years, or what should I do? And I had to make a decision just to re-roof what was there. I don't know what's going to happen to the building, and I really have to say that that I like this building, and I don't want to lose it. But now, it's kind of like, I feel like the city wants it both ways.
If I could just clarify that the comprehensive plan is a policy, it's a guideline for future land use. The city is not going to take your property or your building. It's a vision that was shared by the community that if these properties were to redevelop in the future, at the time that the owners elect to redevelop the property, here's a concept of what might make sense for this area. It's kind of a starting point for discussion. There's no plan for the city to take your property. There's no funds for the city to purchase your property.
But it's
in your control.
yeah, but it's not a good feeling to have it there, nor as as the owner of the property. I don't like, I mean, I feel like it's in, its future might be in jeopardy. I mean, I think you could understand how I would feel to have that on the plan.
Okay, I just wanted to clarify that
I know,
it's
but
not.
it's still, it is sort of like a.
It is not a definite, this is
Okay.
going to happen to your property and we will take the property. It is a vision that was shared by the community through the planning process that it was your property along with others that could present a redevelopment opportunity on the edge of the downtown area. But it would take the owners working together, assembling or deciding to sell, and somebody purchasing and assembling those properties
Okay.
to do anything.
Okay.
So if you don't want to sell, It's not going to happen.
Granted, we're not talking about the conservation district,
I
but
know.
to your point, it would be possible if Ms. Roth wanted to landmark her property to add that other layer of protection on top of it, so that the city would have to go through the HPC in order to.
Or expand the boundaries of the
Right.
downtown
So
historic
this would be an
district.
example of, you feel
That's
that
very
your
positive.
property is threatened, it might be something to consider.
Okay.
That's a mid-century modern building, 1950s, that might be worth thinking about landmarking.
And to tell the truth, because of the way it's matches the other buildings in the area, maybe a group effort, sort of thing. But again, we're kind of off subject.
Yeah.
I just thought, well, I've got the right people here, and this is something that, it's been on my mind for a number of years, and I thought, I'm going to
By the
speak
way,
up.
I like the building too.
Thank you, I do too.
And I do want to just bring up one thing since since Madeline has brought that subject up, and I touched on it last week, but I had a question this week on it. I just wanted to clarify that the demolition process that's outlined in our proposed ordinance is a hybrid demolition ordinance, where most communities actually put a demolition delay ordinance over the entire community as a way to evaluate. So something like if Madeline's property came up for demolition and it's outside the historic district, it's not landmarked, nobody's proposing to landmark it, we don't have the ability, like many communities, the way this is written, to just ask for a 120-day stay to evaluate the building and come up with alternates. I don't think that's something that anybody was asking to have added to the ordinance. So we have a hybrid. We only deal with demolitions that are landmarked buildings or within a designated district. And so there are buildings like the one we're speaking of that are totally unprotected. If somebody were to, say, purchase it, say if you sold it, and everybody thought it was beloved, but it's not landmarked, it's outside the district, the demolition ordinance is not cover it like in some communities. I just want that, I can't underscore enough because that is a question I got this week or last week after the meeting.
But there are communities who have the entire town under.
Chicago's an example that theirs is a true demolition delay ordinance. If it's on a list of, they've got a color-coded survey, and if you're certain colors, no matter where you are in the city, you're on a, you
That's
can
true, because
have a
I dealt
demolition
with
delay.
that.
Yes.
I'd forgotten about that.
But there's a lot of smaller communities that have it as well. That just their demolition ordinance is separate from the historic preservation ordinance, and it's a citywide ordinance.
Okay.
Any other comments on conservation districts? Yes.
I'm tired too, so I'll make this as short as I can. Essentially, I want to say, please consider my previous remarks and make it ditto for the Conservation District. And keep in mind that if you enact the Conservation District, I think you will have covered every single house in the city. And no, what would be excluded? Carolyn, what you're saying, no?
Well, I'm thinking of my house, my neighborhood.
It would be excluded?
I would certainly think so because, well, we do have a number of architecturally lovely properties built in the 60s and 70s, but I can't see all of Geneva being a conservation district. Can anybody else?
Well, it doesn't
Just-
work that way.
Well, just to
Yeah.
clarify,
Yeah.
anything after anything after 1984 would definitely be excluded. So
Anything
that-
after what?
1984 at this point would
This
be
year.
definitely excluded.
So that's Mill Creek.
Right.
Right, but
Okay,
the thing
well,
is
yeah,
that
I stand corrected. But places like Pepper Valley, or the area that was studied west of 7th Street, all of that area could be encompassed into a preservation or a conservation. So it may not, it certainly wouldn't be Mill Creek and those other newer properties, but it would be a substantial part. So I think this is a big undertaking. And I think that when the residents of some of these, Pepper Valley, for instance, find out, they're going to have the same kind of concerns that some of the rest of us have. And I'm not going to go into those again, but just let me say ditto for sure on those. There was one other point that I guess I am getting tired, but, so ditto. Thank you.
Right, thank you.
Actually, may I comment?
Sure.
To Mr. Barty, I don't remember your last name, I'm sorry. Your last name?
Smursage.
Last name is Smursage. First name is Marty.
Mr. Mersage's point, I agree that whatever we decide to do with the historic district as far as our previous discussion, that be mirrored in the conservation district.
Yeah, our goal is to prepare an ordinance that's very parallel, so that you're not having different situations for different processes for different districts or different designations.
Right.
So I think it's 20 after 9, and we're going to have to carry this to a vote on the 17th? Or are we going to try to push it out?
I think what I'm hearing, that there's at least one major section that you want to see a redraft on that would affect 2 or 3 sections in the ordinance. I did have prepared a summary tonight of all the text changes, but I don't think we should go through that till we get this resolved. So I'm not sure that you need to tie yourself to a vote on the 17th, but we certainly can review the language and see if it needs to be fine-tuned any more after the 17th.
So is everyone okay with that? That
On the 17th, we're going to see a rewrite with some of these.
what
things
we're going to
we've
see
discussed in the
is
past 2
his
meetings.
changes, we're not going to see like the whole rewrite of the whole thing.
Just the changes.
Just the changes, we're going to go through that.
I do want to prepare you. You will want to have your Wheaties that night as well, because it's already a very full agenda with cases. And this text changes will be added onto that, so it will be a lengthy meeting.
So it's cases plus the review and rewrites
Correct.
Would it,
on the 17th.
I mean, I'm asking the question, would it make more sense for the commission to be more comfortable identifying a different date where we could focus only on the ordinance?
Well, if I recall, today's the 10th, the 17th is only 7 days from now, and you need to go to legal review. I think that perhaps it's a bit ambitious to ask for a rewrite in 7 days.
Well, he's got most of it rewritten except for this
I
that we
meant
talked about
that
tonight.
one section, because it does have to go to
Well, it's,
the attorney.
What do you think?
I'd like to consult with our attorney on that, on some of the questions, and we would ideally, I guess, like to get the packet out this Friday at the latest.
That's only in a couple days.
All right.
So
But you-
So why don't you figure out if you can get this last section worked out and when that would be, and then can you let us know? And then I don't know if you can put that on the website or something to let the public know.
When do you have your agenda by?
well, the agenda for next Tuesday's meeting will be going out on Friday.
So if it's on the agenda, I guess.
Okay.
But if
But we-
we're continuing this, we really need to identify a
We
date.
want to continue it. Do we?
I think you want to continue the meeting for this meeting to a date
So we
certain.
have to continue it rather than,
Do you need a vote?
Well, it's not a public hearing, so we're not
Well, you don't
closing.
You don't have to, I guess. We could just continue this as a case, right?
Right.
okay.
But do you want me to try to pull this together for you for the 17th, or would you rather handle? I know that there's some dates coming up that some of you aren't going to be available. So we can have another special meeting just for the ordinance, but it would be outside of either the April, sorry, I'm drawing a blank on we have March 17th, and I think it's April 21st.
And then the 31st, if we're talking Tuesdays.
Yes.
Okay, so is anyone not going to be here on the 17th?
I will not.
You will not be here, okay. Pushing it to April, I mean,
Could we do the 31st of March? Is that not good?
I don't have access to my calendar, I'm sorry, I can't say.
I won't be here I can't do it on the 31st.
You
That's a
cannot.
bad week.
It's
spring break week.
It is spring break, yes, that's true.
You're all going to be in Daytona, huh?
That might
No,
mean some
no,
of the residents can't attend
Charleston
that.
doing
Right.
historic preservation stuff.
what about the 21st?
24th? And I won't be here the 24th.
I mean, we can, I would hate to continue this until next week and then not be able to provide the answers.
Right, no, I am fine with pushing it out.
But
I just want to
guess
make sure everyone knows.
an option is we could we could continue it until next week with the hope that we're able to get the answer this week and get back to you next week.
But Carolyn's not going to be here to.
And then, if not, continue it next week.
Do it without me. You can't build this around my schedule. That's not right.
So is everyone but Carolyn going to be here next Tuesday?
Yeah, I'm gonna,
Okay. Why don't you see what you can do? And then just let us know. And I don't know how you let the public know, but,
We'll make sure it's clear on the agenda that goes out on Friday.
okay.
Okay.
All right, so how do we end this? Do we close out the meeting? Do we vote to continue it at a later date, or what do we?
I think for now it's continuing until March 17th.
Okay. Motion to continue this meeting to March 17th?
motion?
Second? All those in favor say aye.
Aye.
Any opposed? All right, we are adjourned.